All right, let's dive into a really core topic for your revision, the separation of powers in Hong Kong. We're going to cut right to the heart of the debate and give you a clear, solid framework you can actually use for your exams.
So, first things first, let's start with the big picture. Why do we even have this concept of separating powers? Well, it all boils down to a single fundamental question. How do you stop one person or one group from getting way too powerful and threatening everyone's freedom? That's the problem this whole theory was cooked up to solve.
And here's the classic solution. The doctrine basically says, let's slice up government power into three distinct branches. You've got the legislature, they make the laws, the executive, they carry out the laws, and the judiciary, they interpret the laws. The whole point is to make sure power is spread out, not all in one place. It's the bedrock of limited government.
Now, this idea is not new. We have to go all the way back to the 18th century and the French philosopher Montesquieu. He was the one who famously argued that if you have these three branches and each one can check the power of the others, then no single branch can run wild. It's a system of checks and balances, a revolutionary idea that shaped constitutions all over the world, especially in the US.
But, things have gotten a bit more complicated since the 1700s. The modern view is a lot more nuanced. It's not really a simple yes they have it or no they don't kind of thing. Think about the UK's Westminster system. The executive and the legislature are actually kind of fused. The prime minister is also a member of parliament. But we still say they have a separation of powers. So the key takeaway here is that it's a spectrum. It's all a matter of degree.
Okay, so with that in mind, let's bring it home to the Hong Kong model. Because while it also has the three branches, you're about to see why the judiciary's independence is so unbelievably important to the whole setup.
Hong Kong is often described as having an executive-led government. What that means is the executive branch has a lot of power. And in a system like that, the judiciary's role as a check on that power isn't just important, it's absolutely fundamental. A strong, independent judiciary is pretty much the linchpin holding the rule of law together. So how do we actually tell if a judiciary is independent? For your exams, you're going to need a solid way to analyze this. So pay close attention, because this is a framework you can lift and apply directly to an exam question.
The starting point, the case you absolutely have to know, is Valente v. the Queen. It's the leading common law case on this, and it establishes this core idea that judicial independence isn't just about the courts as an institution, it's also about protecting each individual judge. And Valente gives us this brilliant three-part test. These are the Volonté factors. First, security of tenure. This means judges can't just be fired because someone doesn't like their decisions. Second, financial security. Their pay is set by law, so it can't be used to pressure them. And third, institutional independence. The courts get to manage their own affairs. Remember this three-part test. It's your go-to framework. Okay, so now that we've got that legal framework in our back pocket, we can finally tackle the big one. The great debate. Does separation of powers actually exist in Hong Kong?
And this right here is the heart of the whole issue. Are we talking about a true separation of powers with real checks and balances? Or is it something different? A system with three branches that just have different jobs, or divided functions, all operating under a powerful executive?
For a very long time, the judiciary's position was crystal clear. Here's what the Chief Justice, Geoffrey Ma, said back in 2014. He stated, very plainly, that the basic law itself lays out the principle of separation of powers. For years, this was the accepted view from the courts.
But then, in 2020, a very, very different message emerged. In this statement from the Hong Kong and Macau Affairs Office, it was declared that any talk of Hong Kong having a separation of powers was just plain wrong and had to be rectified. This was a huge shift in the official language.
So, let's just put these two views side by side because it really makes the conflict pop. On one hand, you have the traditional judicial view. The basic law enshrines separation of powers. On the other hand, you have the official government line. It's an executive-led system with divided functions. It's a fundamental disagreement over what the system is.
And look, this isn't just some dusty old legal argument. It has real, on-the-ground consequences. For instance, the very phrase separation of powers was actually removed from some school textbooks. That shows you how this high-level constitutional debate trickles all the way down to what students are learning in the classroom.
Now, to really see these pressures and debates in action, let's zoom in on a fascinating case study, the role that overseas judges play on Hong Kong's highest court.
For decades, people have called these judges the canaries in the coal mine. You know the old story. Miners would take canaries down with them, and if the birds stopped singing, they knew the air was bad. In the same way, many see the willingness of top international judges to sit on the Court of Final Appeal as a crucial signal, a litmus test, for the health of Hong Kong's judicial independence.
But recently, that system has been under some serious strain. It really started in 2020 when Australian Judge James Spiegelman resigned right after the national security law was introduced. Then in 2022, the two serving UK judges left. And in 2024, two more, Lord Sumption and Collins, also resigned. Now, it's true there have been new appointments, but you can't ignore the trend of these high-profile departures.
And the numbers, well, the numbers really tell the story. Back in 2020, there were 13 of these overseas judges on the panel. Fast forward to 2025, and that number is down to 6. That's more than half gone in just 5 years.
So what's the official response to all this? Well, the HKSAR government has been very firm and very consistent. They've pushed back hard against the reasons given by the departing judges and have repeatedly stated that claims of political pressure on the courts have absolutely no truth to them.
Okay, so how on earth do you wrap all of this up for an exam? The key is to avoid a simple yes or no answer. The top marks are going to go to students who can show a really sophisticated, nuanced take on the whole situation.
And here's a fantastic analogy to help you do just that, something from your professor. Think of it as Schrödinger's separation of powers. You know, like Schrödinger's cat, which is both alive and dead at the same time until you open the box. The idea is that Hong Kong's system can be seen as both having separation of powers and not having it, all depending on how you look at it.
Let's break that down. If you look at it from an internal perspective, just what's happening inside Hong Kong, you see the branches checking each other, you see an independent judiciary. It looks a lot like separation of powers. But if you take an external perspective, you see that the entire Hong Kong system operates under the ultimate authority of the central government. So the key point for your analysis is this. It's possible for an executive-led system to coexist with a unique kind of separation of powers, one that's been uniquely shaped by the whole one country, two systems framework.
And that leaves us with a perfect practice question to chew on. Should Hong Kong keep inviting overseas judges to its top court? You could argue it either way, right? You can talk about international legitimacy, legal expertise, political confidence. There's so much to unpack. Use the frameworks we talked about today to build your answer. Good luck with the revision.